For the same-sex couples who are the plaintiffs, it was a cause for celebration. The 10th Circuit Court of Appeals' 2-1 decision rejects Utah's marriage laws, which define marriage as between one man and one woman.
I could be no more proud to be a Utahn than right now.
In his decision, the court said the 14th Amendment protects the fundamental right to marry, establish a family, raise children, and enjoy the full protection to a state's marital laws.
It has nothing to do with moral beliefs, religious beliefs, or emotional beliefs. It is, what does the 14th Amendment mean in terms of every citizen in this great country and in the state of Utah?
The couples who put their personal lives in the spotlight to bring the case to this point sense relief, affirmation of what they say is their civil rights cause.
Marriage equality really is a family-centric value.
For now, the case will likely be appealed eventually to the U.S. Supreme Court. For Utah's governor, the price tag continues to be worth it.
From my point of view, it needs to be appealed because we can't get finality and final resolution unless the Supreme Court hears the case and makes a decision.
For the plaintiffs, the next rung of the ladder only heightens the significance of their resolve.
I would say victory is never inevitable, but justice always is, and I think that we do have the right side of history to back us up.
This decision is based exclusively on Supreme Court precedent.
And that's why this University of Utah law professor says today's ruling from the 10th Circuit is not a surprise after last year's Supreme Court decision striking down the Defense of Marriage Act.
This court, like many other courts, held that laws banning same-sex couples from marrying violate their constitutional rights. If that's correct, then it doesn't matter how the law was passed. And every single court has found that states may no longer prevent same-sex couples from marrying or refuse to recognize their marriages.
Today's decision is limited to civil marriage and makes it clear that no religious organization has to recognize or perform same-sex marriages, but conservative voices fear the ruling could impact religious freedom.
Any person doing business, individuals, businesses, not churches themselves, but people of faith, as they're trying to live out their convictions in the public square in employment and all kinds of different issues could feel impinged, their religious freedom impinged by a decision of the court that says, you have to recognize same-sex marriage. We still have those concerns.
And conservative groups plan to argue to the Supreme Court that individual states have a right under the 14th Amendment to define marriage.
It just seems implausible to us to say that for the past 140 plus years, the U.S. Constitution has actually required the federal courts to tell the states what their definition of marriage should be. We think that that's an overreach by the court, and we hope one that will be corrected by the Supreme Court.
Our people have spoken on that issue, and that's
one of the principal issues for Governor Herbert, that states should define marriage for citizens. And since Utah's Amendment 3 was passed by a supermajority of voters, that those voices should be that voice. Still, Herbert says the legal process needs to play out.
From my point of view, it needs to be appealed because we can't get finality and final resolution unless the Supreme Court hears the case and makes a decision.
As it stands today, 19 states, plus Washington, D.C., highlighted here in bright red, allow same-sex couples to marry. The 3 states in green, Colorado, Nevada, and Wisconsin, allow civil unions or domestic partnership. In the dark red states, 12 including Utah, judges have issued a ruling in favor of same-sex marriage. Same-sex marriage is still banned in the states in gray. Some are facing lawsuits and are awaiting a ruling.
All of those states now rely on Utah to defend children's relationships and to defend the state's right to define what marriage is.
Those supporting a man-woman marriage are hopeful that once the case does get to the Supreme Court, earlier federal judge rulings will be overturned.
If the court remains consistent to what it held in Windsor, the states will ultimately be free to preserve man-woman marriage, should they choose to do so.
Richard Piatt, KSL 5 News.
We didn't feel it really applied to us.
Forget the stay. The Boulder County Clerk is already issuing marriage licenses to gay couples.
The opinion in the 10th Circuit Court was clear that it's unconstitutional to deny the right of marriage to these people. Our prohibition has denied this right for far too long.
She says the stay doesn't apply in her state. The Colorado Attorney General is firing back. saying the ruling itself isn't binding in Utah, let alone Colorado. But tell that to this crowd.
But this victory today is not just a victory for these incredible people that I'm standing with. This is a victory for all of us to share.
Utah's gay couples gathered at City Creek Park and called scoreboard.
There's just too much precedent going on now anymore. The odds are in our favor.
This is freedom. This is really what America's about. So I'm proud of America today.
They were flanked by a former U.S. attorney for Utah and the Salt Lake County DA.
Love equals love. Thank you.
Gill told the crowd to be patient and to respect the process. The plaintiffs in the case acknowledged more legal challenges ahead, despite the 10th Circuit's landmark decision against Amendment 3.
I would say victory is never inevitable, but justice always is, and I think that we do have the right side of history to back us up.
Utah's gay couples are content for now to wait.
We've been together for over 19 years, and we're finally excited to be able to say, yes, we're married.
From the celebrations yesterday with news the 10th Circuit had decided in a vote of 2-1 that Utah's Amendment 3 banning same-sex marriage is unconstitutional, both sides in this debate are gearing up for one more appeal. While Utah has the option of filing for en banc, asking all of the 10th Circuit Court judges to review the ruling, one longtime Supreme Court observer believes Utah may appeal directly to the High Court.
If the Attorney General is interested in trying to get this case to the Supreme Court first, the Attorney General probably would be well advised to bypass the issue of en banc.
Lyle Denniston also believes yesterday's decision will be more interesting to the justices.
It is a split decision. You have a full articulation of the views on each side by the majority and by Judge Kelly in dissent. And that would be appealing because it would lay out both sides of the argument for the Supreme Court's consideration.
And with a decision pending from the Fifth Circuit that many legal scholars believe could uphold a ban on gay marriage, it would set up a showdown on the issue that the Supreme Court would have to tackle, and that could put Utah's case on the docket.
The Supreme Court's seen this one before. Remember, in January, the court imposed a stay on the trial court's decision in this case. And so this is a case with some track record in the Supreme Court.